That in mind, do I have a motion for the approval of the meeting minutes for January 25th, 30th, 31st, February 1st, 5th, 6th, 7th, and 8th? Representative Eric Smith.
Thank you, Mr. Chair. I move that approval of those minutes.
Very good. Do I have a second? Representative Adam Smith seconds. Any discussion, committee? All right, all in favor say aye.
Aye.
Opposed, no. The ayes wishing to be recorded are, here I was on such a rhythm. The ayes have it. We'll adopt the minutes. All right, we're going to move into our hearing on House Bill 2385, and we will ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2385 creates an inference of an intent to distribute a controlled substance based on the quantity of the substance possessed instead of the current law rebuttable presumption. Section 1 amends KSA 215705. That's the statute that criminalizes distributing a controlled substance or possessing a controlled substance with the intent to distribute. Current law there in subsection E provides that in a prosecution under this section, there shall be a rebuttable presumption of an intent to distribute if any person possesses a certain quantity of a controlled substance. Subsection E in this bill is amended to provide that there shall be an inference of an intent to distribute if such inference is supported by the facts and such person possesses a certain quantity of a controlled substance. Section 2 amends KSA 6416. That's the statute that describes the impact of presumptions. A new subsection B is added there to provide that in a criminal case, any presumption or inference against the defendant created by statute or common law is permissive. The trier of fact may accept or reject the presumption or inference in each case, and the judge shall not direct the jury to find a fact against the defendant. The judge may instruct the jury on the presumption or inference only if the presumption or inference is supported by the facts. When the judge does instruct the jury on a presumption or inference against the defendant, the judge shall instruct the jury that the jury may consider the presumption or inference along with all other evidence in the case. The jury may accept or reject the presumption or inference in determining whether the prosecution has met the burden of proof, and the burden of proof never shifts to the defendant. And I can take any questions.
Thank you, Natalie. There are a number of us who aren't attorneys, so can you define a rebuttable presumption and then also define an inference?
Well, Mr. Chairman, there isn't really a definition of a rebuttable presumption, but essentially, as you know, in a criminal case, the prosecution has the burden to prove that the defendant committed the offense beyond a reasonable doubt. And in this case, we're talking about possession of a controlled substance with the intent to distribute that controlled substance. And in this case, the current statute says that if you have a certain amount of that controlled substance in your possession at the time, then that creates a presumption that you intended to distribute that. It wasn't just possession for your own personal use. If you have this much, we presume that you were intending to distribute that substance. That puts kind of a somewhat smaller potential burden of proof on the defendant to overcome that presumption that there was an intent to distribute, even if they had that amount. And so you'll hear from the proponents, I think, about what the difference in the wording means, but that's essentially how that rebuttable presumption works now.
Okay, very good. Committee questions for Natalie? All right, seeing none, thank you very much. We do have a couple proponents here with us. We'll start with Tom Stanton, Reno County District Attorney, on behalf of the Kansas County and District Attorneys Association. Thank you for being here, sir.
Appreciate the opportunity to testify. I presented written testimony which laid out the history of this statute and some of the things that have happened since a case I tried called State versus Dominic Holder back in 2021. These inferences were determined by prosecution and KBI chemists and others involved in determining what level of drugs would be presumptive. I've looked through this. I've been a drug prosecutor most of my career, last 33 years, until I became district attorney, and I handed those duties off to others, but I'm very experienced in this, and I believe those levels are still adequate and accurate in determining the presumption. The problem is that the legislature used the term rebuttable presumption. And in Holder and in subsequent cases, the court has determined that that has a possibility of creating a constitutional issue, and they rely on the United States Supreme Court in that decision because, obviously, as a prosecutor, I have the burden of proof. I always have the burden of proof, and there should never be a question as to whose burden it is. But when you use that term rebuttable presumption, then it creates an inference that here's the presumption, now the defendant has to come forward with evidence to prove it's not true. The kind of legal issue that we found was that the instruction that the Judicial Council came up for that presumption was actually for a permissive inference. A permissive inference does not change the burden of proof and ask the defense to do anything. It simply says there's an inference, and jury, here's an inference, and if it's supported by the evidence in the case, then you can consider that inference in making your determination. So there's a big difference between a permissive inference and a rebuttable presumption. And while the courts have not yet reversed any cases, a person who creates standing could very well end up in a situation where the Supreme Court says, this is the case, this is unconstitutional. Okay? So what this bill was originally designed to do, when this first came down, it only had Section 1 in it. All right? It only talked about changing the wording of the drug statute from rebuttable presumption to permissible inference. Okay? I wrote that statute, and I thought that was all we were dealing with. But this committee, that was House Bill 2705. This committee sent that to the Judicial Council, and the Judicial Council said, well, wait a minute, we don't really do everything that we need to do by just changing the drug statute, because if you look at my written testimony, there's a number of other presumptions in the law. For example, for certain things can cause a presumption that an item stolen was stolen with the intent to permanently deprive. And there are other presumptions in my written testimony that explain that. So the answer that they came up with, that the Judicial Council came up with, was to modify KSA 6416. And then in that way, it would change the language and affect the language in all the statutes that had a possible rebuttable presumption, even if they used a different term. So that it was clear that in the criminal law, this is what you have to do, and this is the instruction that you have to give. So the instruction that's currently being given would be adequate if you make this change. Right now, the Supreme Court has said that the instruction that's being given, that was presented by the Judicial Council, is legally inappropriate because it doesn't really address the term rebuttable presumption. It is more of a presumptive inference type instruction. So all we're asking you to do is to change the language and to adopt the Section 2. Section 2 is the most important section in this bill because it applies to all statutes. So we left the other is in just to make sure that it's clear in the drug statute that it's not a rebuttable presumption, but that it's a permissive inference. And I think it's clear that we need to make sure that statute is also changed. The language of that statute's changed, so there's not ever a question as to whose burden of proof it is in a criminal case. So I don't know if I have anything else to add at this point, unless you have questions of me.
Certainly. Thank you very much, Mr. Stanton. That was incredibly informative. Committee questions for Tom. Representative Carmichael.
Thank you, Mr. Chair. Mr. District Attorney, good to see you again. I appreciate you being here in person. I think the last few times we met, it may have been during COVID or otherwise, and you were a talking head. It's nice to see you in person again. Thank you. And I was, from your perspective, a talking head as well, I'm sure. I'm really getting old. How long's Reno County had a district attorney?
Well, since before me, I think it happened when Tim Chambers.
In Chambers before he went on the bench?
I think he came to the legislature and kind of pushed that through. So we've been a district attorney since I joined the office in 2001 at least.
I'm glad you mentioned Judge Chambers because he's a very wise judge. I've tried cases in front of him, and he didn't call me a poacher or somebody from out of town. So let me try to work with the chair's permission through a little bit of this, understanding that I'm what would be called in the appellate court a cold panel. I have looked at these issues before. It's been some years. I've briefly read your testimony. As I understand it, one of the elements of proof in the crimes that we're talking about here generally is that the state bears the burden to prove that there was an intent on the part of the defendant to distribute the controlled substance, whatever it might be.
That is true.
And in the absence of that intent, a showing of that intent, you cannot properly obtain a conviction for those intent-based distribution crimes.
That would be accurate.
Now, prior to this most recent line of cases that have befuddled all of us for the past year or two, there was as you say, a rebuttable presumption. And I think that meant that if the county or district attorney only presented evidence as to the quantity of controlled substance involved, that was actually all that was necessary to support a conviction, at least as a matter of law, because there was a presumption that the quantity led to a presumption of intent to distribute, which was, of course, rebuttable. I know a bad question, but are we generally tracking here? If not, help me.
I'm tracking with you, yes.
Okay. But now the court suggests that you've got to prove each and every element, and if you start out with a presumption, be it rebuttable or otherwise, it may have vitiated the state's burden to prove every element, because you could theoretically at least just be relying on a presumption based on quantity.
Well,
help me with this.
In a law school exam, that might be correct. However, as I said, I've been prosecuting these cases I prosecuted them for 25 years or more. I never relied on that presumption. That presumption was.
And that's why I think
I relied on that presumption. I'm sorry, I didn't mean to.
No, I'm interrupting. Please go ahead. We've got plenty of time.
I always made sure that there was testimony and that there was other evidence that would support that inference. And that's what the instruction that we have says, is that there has to be evidence that supports that inference or that what was a rebuttable presumption, but it now is there still had to be testimony. At least that's how I always tried my cases. I never considered a situation for me to walk in and say, how much did you have? Okay, we're done. I've never done that. I've never known another prosecutor in the state of Kansas to do that.
In my complex and improper question, I thought that I had taken that into account. I didn't mean to say that a prosecutor would be foolish to rely upon that alone, and I didn't mean to imply that you or your office was. But now if we change to or the courts require us to utilize a permissible inference rather than a rebuttable presumption, it would seem to follow to me that the inference alone would not be sufficient to obtain a conviction or to support a conviction. Rather, you would need the inference plus other evidence. Now, help me with that.
You would have to have evidence to support the inference. And the way I look at it is this. Most of the people we have sitting on the jury have never dealt with any controlled substances. They don't know what a gram is. They don't know how the drugs are sold. They don't know how much one drug is sold at a time versus how much a different drug is sold at a time. And so those inferences help guide the jury in helping understand what kinds of quantities of drugs are normally possessed with the intent to sell. So if you've got a tenth of a gram of methamphetamine, in my cases, the jury would learn that that's normally for possession. But if you've got 3.5 grams, there's an inference there that is for sale. But I still have to show other things. I would have to show O-sheets, packaging materials, statements of the defendant, or other telephone calls, other things that would support that inference. I couldn't just walk in and say, here's 3.5 grams of methamphetamine, that's all I need.
I would have to disagree with your premise that the majority of jurors in the state of Kansas are not familiar with marijuana, and I think there is epidemiological evidence that would suggest the contrary, but that's not relevant to our discussion here.
That's not all I prosecute. I prosecute fentanyl and cocaine and methamphetamine and other
Okay,
things.
prosecute whatever you wish, but I think we're in agreement that inference alone, based on quantity, would no longer be sufficient to support a conviction as a matter of law, irrespective of what a smart prosecutor might do.
And the only disagreement I would have is that I don't believe the inference was ever enough to support. I understand that it was a rebuttable presumption, but I have never seen in my career someone walk in, prepare or present to a jury, I have 3.5 grams of methamphetamine without further evidence, and walk out with a conviction or even try
Clearly
to
not my
walk.
point, because we agree that that would be a foolish way to prosecute a case.
Yes, but I
I see that the chair grows impatient with our discussion, so we can continue it at a later time. Thank you.
Sounds good.
Thank you, Representative. Further discussion for Tom Stanton Committee? All right, seeing none. Thank you very much, Tom.
Thank you. I appreciate the opportunity.
Absolutely. We'll now be pleased to hear from Natalie Chalmers, Assistant Solicitor General, the Kansas County and District Attorneys Association. Natalie, welcome to committee.
Hi, I'm here on behalf of the Kansas Attorney General's Office. My name is Natalie Chalmers. I am Assistant Solicitor General. Essentially, I'm an appellate prosecutor, so appeals are my bread and butter. I've been doing appeals for the AG's office since 2011. I am also a member of the Criminal Law Advisory Committee to the Judicial Council. So this was subsection 2 was a bill that I helped draft with the assistance of Professor Concannon, for those of you who know him from Washburn. Essentially what happened is by United States Supreme Court case law, a mandatory presumption is unconstitutional. A permissive presumption can be constitutional, but you have to do it right. And then a inference is always constitutional, because an inference is basically just people using common sense or connecting the dots between evidence to reach a fact. What happened in the recent cases is the Kansas Supreme Court said, as the DA has already explained, essentially, the statute says shall, that's a mandatory, but we're not going to reach it because you don't have standing. The instruction was fine, and so they didn't reverse. They only reversed in one case, and that is State v. Schlusser, and that was when the prosecutor in closing argument used the word presume and specifically said something about this legislator said this was enough, so it should be enough, and had some other errors in there, and they did actually reverse that distribution case. The way we want to fix it is a way about half the states already fix it, where you go into the presumption statute and you basically say, if you use the word presumption, it is always permissive. You have to meet these certain factors that the DA already talked about to give the instruction. And then it's something the jury can always reject, and it never shifts the burden of proof. So the statute itself would fix any problem without us having to go into a dozen or so other statutes that use the word presumption. I would say that despite initially drafting this and liking it a lot, I have an improvement maybe. So in subsection B1, at the very end, and this is in my testimony, I would like to add the jury instruction may refer to any presumption as an inference. Oh, I'm sorry. Line of the statute? Yeah, okay. Yeah, yes. It would be line 29 on page 4. And the reason I want to do that is because right now it just says presumption or inference. But in the Legislature case that I talked about, the Kansas Supreme Court, sorry, I'm really thirsty, indicated that the word presume means something different than inference. I don't know if most citizens would necessarily immediately see a difference in that word, but just to be safe, we would prefer to keep the PIC instruction that we've all used for so long and use the word inference. So that's why I'm suggesting making it explicitly clear so there's no question that if you use the word presumption, we can change it to inference in the jury instruction. So they don't have any more problems on appeal on that issue. And unless there are, well, I'll stop talking. And if there are any questions, I'd be happy to answer them.
Sure, thank you very much, Natalie. Speaking of somebody that talked too much, I believe you referenced a legislator that may have talked too much and some...
Oh, no, the prosecutor actually referenced this legislator as saying the legislator, the whole of you, have just said 3.5 is enough, and if it's good enough for them, it's essentially good enough for you to convict, so.
Gotcha. I thought I was referring to some legislator that likes to talk too much. I wouldn't know any of those, by the way. All right, committee, questions for Natalie. Representative Carmichael.
Thank you, Mr. Chair. I would observe that the Kansas Court of Appeals has found favor upon not only my comments in conference committees, but also those of Leader Miller in a decision some time back. And so sometimes what we say here does in fact assist the court in determining cases, and I do appreciate your courtesy in allowing me to ask questions. In your judgment, would an inference standing alone without additional evidence to demonstrate intent be sufficient to meet the state's burden?
No.
So irrespective of whether the jury is instructed on the inference, your opinion is the prosecutor would have an affirmative obligation to introduce other evidence in support of the requirement to show intent in these types of crimes?
Just saying that there's 3.5, I'm going to use methamphetamine because
Right.
it's what I know off the top of my head, would not be enough ever. There would have to be additional evidence to support the fact that there's distribution.
That there were scales or bags. I'm not an expert on methamphetamine. I can talk a lot about weed, but not meth.
Often it can be scales, it can be phone calls,
Right.
sometimes prior crimes. It can also be the fact that the officers come in and say, hey, this is our community, this is what we see as distribution level. But something has to factually support that inference before the jury can ever make it. And just saying this is an inference would never be enough to prove.
So then why do you need the inference at all? Why isn't just the testimony of your witnesses sufficient to say, look, this guy had scales and bags and whatever other paraphernalia is needed to distribute these products?
It could absolutely be enough, but as Representative Stanton has said, not all jurors are familiar with that. I think it's just helpful. Also, the United States Supreme Court and the Kansas Supreme Court regularly talk about how inferences are essentially the bedrock of the judicial system. So, and I'm not just in here because of the drug statute. It is all the others. And you don't have to give the instruction. Prosecutors can choose not to. But if we want to give it, we want it to be constitutional. And also, I have a concern if we don't fix it for any kind of bench trial, where we then have a statute that is potentially unconstitutional coming in, and how do we basically ensure that the judge didn't say, well, this is the law, so I relied on that. So in order to have bench trials, I think we need this fix.
So finally, with your leave, Mr. Chair, it sounds to me like we could eliminate presumption, rebuttable presumption, and inference, and you could still prove your cases with evidence rather than inferences and presumptions. Is that incorrect?
I mean, yes, we could. I think they are still helpful. I think we use them in a variety of reasons. One of the ones that comes to mind is if you find a dead body in a county, you can presume that the murder occurred there. So that's a venue jurisdictional statute, which may or may not fall in the same realm. But yes, we do not need an inference to prove our case. It's the same argument or a prosecutor would essentially make to the jury, which is, this is our evidence, this proves that. But the inference instruction is helpful, and prosecutors would like to have it, and we need to fix the statute. And again, this is the easiest way to fix statutes rather than going into each individual one.
I really appreciate the discussion. I think that's why some would say that inferences and presumptions are shortcuts to justice. Thank you, Madam Chair.
We would definitely never want to infer that. Representative Eric Smith.
Thank you, Mr. Chair. So on the other side of it, maybe, with law enforcement, we pay attention to these things as well. I don't think we've ever trained anybody to look for quantity and walk away. I don't. And I remember, of course, I've always tried to explain when writing reports, if you make any assertion, have facts to back it up. Don't ever just assume, well, because I'm a cop and I said so. And so that's kind of the thing. And when I think of an inference or presumption, both of them are assertions, right? But the word, I think, presumption is, the problem that we have with that is that we're saying that the burden shifted when we say presumption. And inference means I'm going to tell you that quantity does not look like personal use. That's my inference when I'm saying it's 2 kilos of whatever it is. I think that this would probably change nothing for law enforcement and how they do their job out there, except to be certain that there has been a problem in the past. So make sure you're doing your job in your report, that you're supporting this with facts, just as we've always trained you. But, kind of one of those things where you point to it and say, see, that's why you don't just assume. Make sure that you explain it so that everyone understands we are not presuming anything from a large quantity. In fact, I can remember a case where we found scales and we found packaging and we found everything you need, but we only found a little bit of marijuana in a cigarette pack, right? So could we then presume or infer that that is a dealer? No, we couldn't. We needed that quantity to show that it additionally supported. So sometimes it goes the other direction as well.
Essentially, juries make inferences, and they use their common sense and they use the evidence to go to beyond a reasonable doubt all the time. This is just a guidance on specific facts. So drug quantity is one, but yes, we'll always need additional evidence.
Very good. Thank you very much, Natalie. Any further questions? All right, seeing none, thank you very much. Committee, there is written only neutral testimony from Christy Moles and Staff Attorney, Kansas Judicial Council. They are the ones that, of course, took up the request and worked diligently on helping to provide this solution. It's quite extensive if you want to dig very deep into the difference between rebuttable presumption and inference. I don't see any additional testimony, no opponent testimony. All right, with that in mind, committee, we will go ahead and close the hearing on House Bill 2385. Thank all the conferees for being here today. And then we'll move into final action on House Bill 2654 and ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2654 excludes certain types of incarceration time from being included in the allowance for time spent incarcerated when calculating a criminal defendant's sentence.
Any questions for Natalie, committee? All right, seeing none, there is an amendment on this. If you'll go ahead and send that out. This was the amendment that the parties agreed to, if I recall, and as that is being sent out, I'm going to have Natalie step us through this.
Let me get it shared here.
Sure. Let's make sure that Representative Wynn and Representative Miller get that as well. Thank you. All right, does everybody have that in their inbox? Natalie, you want to step us through that?
Sure. Thank you, Mr. Chairman. So I spent a little while in a meeting with both Natalie Chalmers and Jen Roth, who are the proponents and opponents of the legislation. And this it represents the agreement that the two parties came to. So the first sentence there in subsection A1 is intended to essentially codify the holding of Hopkins, which is that the defendants are entitled to have credit applied for each day that they're spent incarcerated. And then the paragraph 2 that we're adding will create two exceptions to that general rule, which are that any time awarded as credit in another case, when consecutive sentences are imposed, or any time spent incarcerated in another jurisdiction if no hold has been issued in that jurisdiction. And I can take any questions.
All right, before I do that, I'll go ahead and move my amendment. Do I have a second? Representative Turk. Questions, committee, on the amendment? All right, seeing none, I'll close on my amendment. All in.
Wait. Discussion, I heard you say questions, and I thought you meant questions for the revisor. I was waiting.
Questions or comments?
There we
sir.
go, thank you. I apologize, I was too quick on the trigger this morning, and Chairman Delperding's, so I'm just trying to comply. Now, you may like what I'm going to say. I want to compliment the people involved. You know, this amendment reads clearly to me, and I think that this is a substantial improvement, and I think it will remove some ambiguity, and I'm glad to see the process work. Thank you, Mr. Chair.
Certainly. Any further questions or comments, committee? All right, seeing none, I will close and move my amendment. All in favor say aye. Aye. Opposed, no. The ayes have it. Those wishing to be recorded in the affirmative are Representative Carmichael and Representative Martinez. Very good. Committee, on House Bill 2654, is there additional amendments or discussion? Seeing none, do I have a motion as it relates to 2654? Representative Eric Smith.
Thank you, Mr. Chair. I propose we move 2654 as amended out of committee favorably.
Very good. Do I have a second? Representative Adam Smith seconds. Any further discussion? Seeing none, would you close?
I close.
Very good. All in favor of passing out House Bill 2654 favorably as amended, say aye. Aye. Opposed, no. The ayes have it. Those wishing to be recorded in the affirmative are Representative Carmichael and Representative Martinez. All right, committee, that concludes our work for today. There are a couple of bills on final action for Monday. And so take a look at those and get with Natalie if you have any questions, concerns, amendments, anything along those lines. Other than that, we will be adjourned, and I would encourage you to enjoy your weekend. Thank you.